And News 24 is reporting that the legal team for former President Jacob Zuma had requested financial statements from the ANC. But the party reportedly claims it no longer has the documents. The ANC has apparently revealed that all party documentation dated before 2005 was destroyed by flooding in a building, and that no party auditing was done between 1997 and 2000. Well, Zuma may well be looking for evidence to prove that he didn't receive any bribes in the arms deal corruption case. Political and legal commentator Sinawo Makangela chats just now from East London in the Eastern Cape. Sinawo, this time it looks like a setback from Jacob Zuma. What do you make of the ANC having no records predating 2005, especially not in KZN, when Jacob Zuma at the time was an MEC?
Well, good morning, Annika. Good morning to the viewers. Indeed, it looks like a setback to him in preparing for his case. But, well, the ANC may be a public body that by law is obliged to provide an information to anyone whose rights are affected by the information in its possession. Or it can be a private body. But however, in terms of the Act, now, what the former president has to do if he wants to pursue that matter further, he will have to follow what the Promotion of Access to Information Act provides. If he strongly believes that information is in the possession of the ANC and it's going to help him in preparing his own defense. Well, it may appear as well that this is one of those delaying tactics. Remember that on its own, it's a process that is regulated by a legislation, which is it has got its own timeline. If he strongly believes that the information is in the possession of the ANC, and then the ANC does not come forth with that information, he may go to court and say, court, please, I want this information. It's in the possession of this people, and I want that information to prepare for my own defense. However, as I say, it may appear as one of those delaying tactics by the former president to delay his trial in the Pietermaritzburg High Court. But it does not only end there, Annika. It does not only end there, because one of the most important things is for the court to consider the relevance of that request in the criminal proceedings that are before court. Of course, as we all know, that there are safeguards. The court, in terms of the legislation, is empowered in the Constitution to consider that which would be serving before it. Because whatever date that is arranged, let's say first term next year, March, April, still the information is not in possession of the former president. He approaches the opposed court in the North Gauteng, where the information is kept, and then the dates are in 2023. But now he approaches the Maritzburg High Court to say, look, may then this matter again be postponed because there's an information that is in possession of the ANC that I want. The judge presiding over the matter, which we now know that it's Judge Kuhn, because it has started the trial, would have to consider that which will be serving before him and see the merit of that particular application for postponement pending the availability of those records.
Sinawo, there's that saying, justice delayed is justice denied, and this case has been stop-start mostly by Zuma and his Stalingrad tactics, but also by the state in one or two instances. Johan van der Walt, the chief forensic auditor, he has passed away. The Tint and Tallers, some of those main players, they are no longer available. They're medically not sound enough to testify in court. We've got these documentation that are not available. How much of a blow is this going to be for the state?
In fact, Annika, the records are not the subject of the litigation in Pietermaritzburg. It's an information that the accused person believes will be of assistance to his own defense. Hence, I say, if we would be coming before Judge Kuhn and say, I need an information that is elsewhere, he would have to make a substantive application, and then Judge Kuhn, empowered by the law, would have to consider that application before him and see whether it has a merit that makes him, that would allow him to grant whatever postponement, because the trial has started. There is also, in terms of the norms and standards, to say once the trial starts, it must be completed within a particular period of time. So even himself, he would not want to act outside those norms and standards of the judiciary. Is expected to finalize the matters expeditiously. Hence, whatever application that comes the way, he will have to consider it in terms of the law and apply his mind as empowered by the law. So it's one issue that is a bit far, first from those that are in the Pietermaritzburg High Court. But it does not mean the door is closed because the law allows any party to make an application for access to any information, but it would depend if the judge believes strongly that that would be the reason for him to adjourn the matter until he gets an information. But then again, another issue that short-circuit the issues is if the Treasurer General of the ANC, Mr. Paul Mashatile, just prepares an affidavit, because the law says if you say you are not in possession of an information, prepare an affidavit, gives an evidence under oath to say we no longer have this information. And then there is no court that can issue an order that is incapable of being executed, because the court cannot say you are directed, ANC, to give this information when it has been made aware that that information is no longer available.
All right, thank you so much, political and legal commentator Sinawo Makangela. Thank you so much for your time. And if I remember correctly, the former president's medical report should be submitted to the involved parties by today.